Hi, you're listening to the Lawyer Society legal podcast for lawyers, practicing advocates, law students, and judicial exam aspirants. In this episode, we'll be talking about the various powers a magistrate has under Section 156, Clause 3 of the CrPC. Now, it is common knowledge that when an informant approaches a police with any information regarding an offence and the police refuses to register an FIR, he can approach the SP or the Commissioner of Police, as the case may be, under Section 154 Clause 3. Now, after that, he can approach the magistrate under 156 Clause 3 of CrPC if the police officer in charge of the police station has not taken any action and the SP or the Commissioner has also not taken any action. Now, the magistrate hearing a petition under Section 156 Clause 3 has the power to direct an investigation to be made in that particular case. When he makes such a direction, the police is bound to register an FIR and proceed. But what else can the magistrate do? Generally, he can direct an investigation, that is known. But what else can the magistrate do? It is said in the case of Sakiri, Vasu versus State of Uttar Pradesh that a magistrate can not just direct, but he can also monitor an investigation. He can ensure that a proper investigation is made. So this essentially means that when the informant is approaching the magistrate with an application under Section 156(3) and the magistrate makes a direction, subsequently if the informant is aggrieved by the progress made by the police, he can still approach the magistrate under 156 Clause 3, stating that he had previously gotten an order from the magistrate and the police had refused to register an FIR or registered an FIR but did not investigate properly. And when he does so, the magistrate can still order that a proper investigation be done in that regard. Now, subsequently, the Supreme Court has also said in several other cases that the magistrate does not just have the power to order proper investigation, but he has the power to monitor that a proper investigation is being done. Also, he can recommend the SP or the senior SP, as the case may be, that there can be a change in the investigating officer who is in charge of that particular case. So all this has been stated in the subsequent cases. The power regarding the change of SP was discussed in Sudhir, Bhaskarrao, Tambe versus Hemant, Yashwant, Dhage, which is reported in 2016 6 SEC 277. The citations have been left below in the description box, and there are also 2 or 3 more cases which dealt with the same aspect, and I will leave the citations below in the description box. I hope this was useful to you, because when the police doesn't investigate, it doesn't mean that we should be approaching the High Court under Article 226 or Section 482 of the CrPC. We can still approach the same magistrate with an application under Section 156 Clause 3, again praying that a proper investigation be made, or praying that the magistrate monitors the investigation, or that there is a change in the investigating officer who is conducting the investigation into that particular matter. So it is evident that the magistrate does not just have the power to direct investigation, but he has all the powers that are incidental to such power, which is taking care that proper investigation is done. And to take care that proper investigation is done, he can also change or at least recommend the change of the investigating officer. Thank you for listening. Please do subscribe to us on YouTube if you're listening to this on YouTube, and do follow us on Spotify. Do share your thoughts in the comment box. Share this with your friends. Thank you.